Hey guys, it's Mo from Mo in the Deep End, and today we are going to finish up. Hello, Amy. We are going to finish up day one, kind of the opening statements, because there was a lot of back and forth and argument between Gravely and I can't remember her name just yet. I've already. It's been a long day already, but I did want to show you guys. So, see if I can. We did get the murder board. Now, I'm looking for a camera like David has that's all fancy schmancy and can zoom and stuff. Amazon Prime Day, I'm a coming for you. But, you know, the murder board, it's fantabulous. It's amazing full. And as soon as I get the zoom in camera, you can see it. It'll be great. You'll get to see my terrible, terrible handwriting. It'll be awesome. Yes, it is. It is up, and now I am just waiting for Prime Day for a zooming camera. I've got my eye on one, but I'm hoping that it will go on sale because y'all know I love a sale. But let's get into this because I want to see them fight. Well, I mean, I want to look. Y'all, I am trying to be unbiased, but Gravely's voice is already starting to kill me already. I may or may not have an emotional support vodka. I'm just saying. Besides, we had to give all of the boys haircuts, and they hate haircuts. I don't know why. We do them at home because haircuts have gotten expensive for boys. They used to be like $11. Now they're about 25 if you're nice to your stylist, and I always am because my boys are terrorists. I'm not drunk yet. I just had some, I was able to fight my feral family for some taco meat. So that's awesome. But here we're going to listen to them argue and shenanigans. Yeah. Can I press on of the I'm getting ready to get into the beginning of it. This is just a little backdrop. If you weren't here for the defense and state's opening statements, this is a little bit after the defense started their opening statements. There was a hullabaloo and they asked to switch it up. And let me pull this back down so I don't have to crane my neck. So this is them just lawyerizing it. Now, y'all, I'm going to go ahead and disclaimer it. I am not a lawyer. Y'all know that. If you're new here, you now know it. I'm not a lawyer. So, they may say some lawyerly things, and I will ask MLS or other, legally people what's going on because, y'all, I got no clue. I am here for entertainment and, social commentary ish. I'm here for shenanigans. Let's be very honest. Okie dokie. Let's get going. I have the booster on.
There will be further argument from the defense. Attorney O'Bear will be handling that.
Okay. You have the floor.
Make sure I'm turned on here. Okay. We did some more research over the lunch hour, and I wanted to point a couple of things out.
I like his hair. I know I
in the
made
context
fun of a bunch of hair, but
the particulars of this case, it's very obvious that the defense is that Mr. Anderson did not commit the offense. So this is not one of those defenses where we're attacking an intent element or the manner in which something was performed. Our theory, of course, as the court is well aware, is that he didn't commit this alleged crime. The comments that were being made by Attorney Mueller during her opening statement were part of a larger argument and in proximity to the point that she had just previously made, which is that that the investigation focused solely on Mr. Anderson. And in fact, the words that she made in
y'all, if I swear to goodness, if some Listen, I am a mouthy female. I have a face and a voice and just a way of talking for contempt, okay, of court. So I would never be a legal lawyer in a courtroom because y'all, I would end up on some compilation video, A&E's most weird in court or something. But yeah, I would lose my ever loving poo if someone said, "That's you can't do that. You're not allowed to make a defense." It's devastating to my case.
terms of what our whole theme and theory of this case is, that there was a script that was written. Mr. Anderson was the central player, the main starring role in this script. Now, as in any case where there is an investigation, and if it's the defense's intent to argue that the defendant did not commit this offense, it's part of virtually every case where reasonable doubt is what we're.
And that's really where I'm coming from. This might not be a super long stream. I don't know if y'all are new here or not, but I have a condition called complex regional pain syndrome. And for some reason, my leg spazzes out when we have storms. So I did Sal's stream and I'm going to be doing 2 streams tomorrow. So I might not get as far as I had intended. It looks like we have about an hour left of this, and then we'll be officially done with day 1. But I wanted to go ahead and get this done and try to keep up with my schedule. Again, if you are new here, I have 6 children. It is summer break. We are just trying to keep the house from burning down.
Addressing. Am I not being loud enough? Reasonable doubt. I'll try to talk more directly into it. The angle's funny here. So it's really a matter of looking at what the entire investigation entailed. Everything that Attorney Mueller was discussing in her opening statement was based on information that had been provided by the state. Now, there are a number of different scenarios in which Denny can be applicable. And just taking a step back as to what the purpose of the Denny rule is so that on a very basic level, the defense can't create some sort of theory that the man on the moon or an alien from outer space came and did it without any support for that. But on another level, if, let's say, in the course of a defense investigation, evidence is uncovered
Okay,
that
so
could theoretically.
I'm going to write down different things to possibly do smaller, shorter videos. You know, I love my children, but they move every daggone thing that I have. Or I just don't see it and I blame them, which is also true. But I probably will do a video on what I can research and or have a note to ask MLS law or one of the other actual legal law people, lawful law people, what the Denny rule is and how it applies. So that might be a smaller video, or one of the things when I do maybe like after week 1, I'll get David on and kind of ask him my collective, what in the lawyer are we supposed to be doing with this? Questions.
Theoretically point to a third party perpetrator. The reason for the notice and procedural rules behind that scenario is that the state then should be given the opportunity to investigate with their resources as to the viability of that potential third party candidate. This is different from that in the sense that we're talking about evidence that was turned over from the prosecution to the defense. And our point here is merely that, and this is one of several different points, things that were not followed up on. So what I was looking at over the lunch hour is, interestingly, some aspects of the Kiles versus Whitley case, which the court's very familiar with, from 1995. Now, that case initially, of course, resulted in a reversal of a conviction and a death penalty based on the fact that there had been withholding of
Sorry, guys.
exculpatory evidence.
Counsel, can you cite so that the parties have a chance to read it as well?
It's Kiles versus Whitley, 514 U.S. 419. 514 U.S. 419.
Okay, and I wrote down that
United
case
States
so I
Supreme
can
Court.
look up what maybe that means.
That case had to do with the fact that there
And
was evidence
yes,
that had
according to
been gathered
Salvador, there
by the
was already
states or
a
the
mistrial.
prosecutors in that case. And a decade after the conviction had occurred, it was reversed because it was determined that there was important information that the state had not provided to the defense. And it's interesting to note why the Supreme Court found that that information was vital to the defense. And it's basically precisely what we're talking about here. The Supreme Court held that it would have and should have been useful for the defense to be able to establish that the investigation was shoddy. It could have raised opportunities to attack not only the probative value of crucial physical evidence and the circumstances in which it was found, but the thoroughness and even the good
I'm
faith
feeling
of the
very confident
investigation
now,
as
Sal,
well.
very confident.
Their disclosures would have revealed a remarkably uncritical attitude on the part of the police. The defense could have examined the police to good effect on their knowledge of another party's statements, so have attacked the reliability of the investigation in failing to even consider other parties' possible guilt. This is right out of the decision.
I mean, this seems very apropos, and listen, y'all, like I said, I'm not a lawyer, but this sounds exactly like what happened if I'm listening to the opening statement correctly. I mean, according to my notes, they basically went from Sadie's initial pointing of a finger to directly Zach, not anything else. I mean, and it's the opening statement, so maybe it's bare bones, but according to my sneak preview and spoiler alerts, it doesn't seem like they were looking at any other people in this man's life. So, yeah, I am not feeling very confident. Yeah, he's just such a again, I want my justice system to be fair in case I am ever in need of a justice system, and I'm a whole lot too mouthy to, not need a justice system at one point. Yeah, there are some people that should not put their faces in public. They should, mom should probably tell them, like, sweetheart, I love you. I love you to death, but you can't sing, so you can't be on American Idol, and you got a punchable face. Don't be a dill hole, okay?
Trial tactic of defense lawyers is to discredit the caliber of the investigation or the decision to charge the defendant. So this was, and put in context, this was evidence that back then the prosecution believed wasn't exculpatory. Whether it was negligently not provided or deliberately not provided doesn't really matter. But the
Boomered already. This is part of me that really is very bothered by this. Listen, if we assume he's passed on, regardless of how it happened, some mom has lost their child. Some children have lost their father. Regardless of how good or bad he was, he deserves justice just as much as Zach deserves justice. They both deserve to have, competent people work to find the answers. I don't get how this was even an investigation like this. I don't get it. I've seen good investigations, and it ticks me off when they're bad.
point is that Kyle's specifically acknowledges the legitimacy of attacking the police investigation in the form of the negligence of the decisions that were made by the police that were not anywhere within the means or the control of a defendant or a defendant's attorney's investigation into the case. I'd also just point out, I'm sure the court is absolutely well aware of this, that when the state makes a motion for a mistrial and when the defense objects, the standard is manifest injustice. And I don't think it rises to that level. So again, I think that what Attorney Mueller was doing here, very consistent with her entire presentation as to the the quality and the integrity, basically, of that law enforcement investigation by pointing out things that were not looked at and were not pursued. I know that there was one, the objection
Yeah,
was that
y'all, this is, I mean, honestly, I know everyone's gonna have, like, their DNA and all this other stuff and things that really bother them, but with just what I know right now, the part of me that feels the most slimy about this investigation is, again, these deep forensic interviews with this child. And children are so easily led. If she knows that mom is sad and, mom is mad at dad and say dad ticked her off or something. I mean, let's be honest, you're a 12-year-old girl. The wind is blown the wrong way today, and you are just ticked off at humanity. It happens. We've all been, well, okay, those of us who are female have all been 12-year-old girls. We are crazy. We are emotional time bombs at 12. Oh, well, I'm glad. I'm really glad. I look, this girl, I hope she is getting help. Regardless of, whatever outcome happens, I'm sure as a dad, I'm sure as an Uncle Solomon and an aunt, all of his family are gonna want this little girl to deal with all of the BS that she's gonna have to deal with this. Regardless of how she, comes to feeling at the end, as a parent, you'd want your kid to find some sort of peace for that, and I don't like that they used her. I don't like that they didn't, according to my spoiler alerts, didn't, provide the videotaping of these forensic interviews, how long they were. It seems very, very slimy to me.
it appeared to be bringing Ms. Beecham in as a suspect or a prime suspect, or however Mr. Gravely was concerned about that. I think that's, if there is a concern along those lines, I think that's easily remedied by the
Yes,
very
you
simple
can, sweet.
instruction that I know the court's given many times, which is the opening statement is not evidence. Ladies and gentlemen of the jury, you're reminded that the opening statement is not evidence. I think that takes care of it. But while we're on the subject, the concerns that the defense has is that this is one of a series of issues that we've been intending to raise regarding the decisions that were made by law enforcement as to what avenues they would pursue. And I think it's very clear that one thing the court could preclude the defense from doing, and I'll tell you, we've never intended to do this, is that we can't get up and argue in front of the jury that Sadie Beecham did this. I mean, we would never intended to do that anyway, but if the court wants to order us not to do that, that's fine. But looking at how the investigation was conducted and what issues were looked into, again, evidence raised, which is right within the discovery that was provided by the state here. I think it's entirely permissible and the court should allow leeway for the defense to talk about all of the things that happened leading up to where we are today, that are part of the investigation.
Yeah, that's the one thing. Look, there are a multitude of reasons I didn't cover this. I was dealing with a lot of stuff. We were 6 kids. I know you're going to be shocked, but I was somewhat busy. But also, Zachariah happened to be the name of my late first husband. It's been years and years ago, and he had, some problems. And the thing I would never do to my kids that got me a lot of flack from everyone who knew me was I didn't ever talk down about their dad, because every kid deserves to have, some kind of look, even Rosario Gutierrez, who seemed to owe everyone money. Those kids deserve to remember their dad with all that adult BS in it. Whatever good they can remember, they deserve that. Oh, people are I already hate the prosecutors. And I feel bad because I'm supposed to be going into this unbiased. Look, personality-wise, I don't like Gravely. I am willing to listen if he has some evidence. If he has the magical, like grassy knoll bullet, I'm willing to listen. But personally, would I go out and have a drink with the man? No.
Obviously within the bounds of relevance, but the court's also familiar that, if there is some issue that's being claimed as unfair to the state, the court can fashion a remedy, such as a corrective instruction. The court should also consider, I don't have the site.
Thanks,
but
Amy,
someone can
Ohio.
look it up real
That's
quick. Chambers versus
look, it's something each parent, like if you look, losing a loved one, however it happens, is a sucktastic club to be in. It just is. It's all the suck everywhere. So, I feel like I made the best choice for my family. It might not be the best choice for everyone's family, but I can totally respect you, Amy, Ohio, for choosing that. That's what I chose. So I may be a little biased, but
Mississippi, that I know the court's familiar with, that requires the court to interpret any particular rule in favor of the opportunity to allow the defense to present a defense.
You got it.
Thank you.
And let me just put the site for Chambers, Your Honor, 410 U.S. 284. That's from 1973, United States Supreme Court.
Thank you. Did you need me, Judge? Okay. Mr. Govey?
So, Judge, first of all, the defense did file a motion, a Denny motion regarding Michael Campbell. We litigated that extensively last week. Both parties did an investigation pursuant to that. And that allegation was completely based upon, as far as I know, was completely based upon evidence provided by the prosecution. So for the defense to say that in this case, they don't need to, that we're on notice because the evidence was already in the state's possession that they wish to use, they didn't feel that that was that precluded anything in the Campbell case, which was identical. I want to tell the court, I want to make the record, this is intentional. The defense in their voir dire chose to emphasize that if you can reconcile the evidence based on any reasonable hypothesis, this was one of the specified questions by the defense. Then I think that...
well, okay, that seems to be normal. You're supposed to, if you have a reasonable doubt, if you have a reasonable doubt, then you are supposed to go not guilty. Maybe I'm reading it wrong. I mean, look, y'all, I am naturally blonde. I dye my hair red to warn the world that I'm a whole lot mouthy and a whole lot, maybe not. Yes, so this would be the man with the shock of white hair would be the lead for the state. And then I believe his name is Gravely.
Transcript is abundantly clear as to what's going on. First, on page 4 of the transcript, defense counsel in her opening describes ignoring legitimate leads and follow-ups and suspicious people. In her very next paragraph, so literally seconds later, she says, so what did they ignore? Again, talking about leads, follow-ups, and suspicious people. They ignored Miss Beecham. So has to be a reference to suspicious people. I'm in the middle, line 15 of page 4. Because Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on May 19th. Remember, she's the first one to find the bloody scene.
Yes, and how many times have murderers found the body? I mean, does a certain border agent come to mind? He acts like he's never had someone say, "Oh my gosh, I found my husband or my wife and she she had the coof and I accidentally married another crazy lady 2 weeks later in Hawaii." Like we haven't seen people. I'm just saying, y'all, he acts like this has never happened before.
Okay, so casting suspicion on her for having criminal conduct. Now I'm on page 5, the second full paragraph. Sure, there could be an innocent explanation to that, but you'll also hear evidence that Mrs. Beecham had constantly been texting with her best friend, Rebecca Jekyll. So now she's indicating, based on her being the first one to the scene, I want to be sure you know about this texting conversation with Rebecca Jacob. Then on line 9 of page 5, she says, this is all on May 4th.
So they're upset that Sadie's being brought into question again. For us in the back room who have watched all of the serial killer and true crime and Lifetime movies, yeah, sometimes it's the person that finds El dead body. Oh, okay. For the love of Cheetos. I don't understand why it is that he wants to protect Sadie's good name so much. I
14th,
mean, other than her being like a
2020.
star witness.
She's complaining about it. Text messages between her and her best friend, Rebecca Jacob, referring to the fact that Anderson, the defendant, is up to monitoring her, etc., but she can't prove it. Her frustration.
Y'all, that is why I am doing this in short intervals, because this man, look, it might just be me, but he feels like he's always yelling or just being aggressively loud. I don't know. It's just something about his intonation and his pacing and his cadence just already. That's why I have an emotional support drink. I'm just saying. Yeah, that's the thing. If I mean, to me, in my non-legalese, I would want the state to completely exonerate the person that found the body, especially when we know that, according to different people, you know, Mr. Gutierrez was either the love of her life now or she was a side piece. Yeah, I don't.
That I can't stop him based on legitimate means is the allegation there. And so then we get down to the crux of it, line 15 on page 5 and on, where she says, Mrs. Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is that it will begin and you will not know when, where, or how. Call me in 1 week. And then she goes on to draw a direct connection. What's 1 week later? When she's at Gutierrez's apartment. So I don't know how more.
I mean, I'm not Velma from Scooby-Doo, but that would seem like a clue to me. Like that would maybe get my spidey senses a little going, but call me crazy, but like, hey, and like me, most of my friends are true crime people, so we don't say anything on texts.
Clearly, you could try to line 5 things up in a row to say that these 2 women are part of a conspiracy to have Mr. Gutierrez murdered and to frame Mr. Anderson. This is what's being alleged here. There's no mystery to it. It connects all the dots and says you just need to read the lines. And it's in the context of saying that it's a suspicious person.
Thank you for stopping by, Iris.
Considered, should be looked at. So it is, Judge, you heard the argument from the defense that this is based on a defense of errors of the investigation. Okay. And of course, that's a legitimate avenue to pursue in investigations. We don't deny that. But that's not an exception to Denny. And if it was an exception to Denny, then Denny is emasculated. The Denny case doesn't exist.
Have y'all been around this year? Like, emasculating things is what we're doing here lately. Did y'all see Indiana Jones? I mean, it should have been Indiana Jones dialysis and the plucky young woman who saved everything. While being super annoying.
A defense attorney, every time they were caught and said, you know what, you're supposed to do a pretrial motion before you accuse someone of doing a homicide in front of a jury without notice.
Yeah, I have noticed that, especially
every
in the
time
written
someone's
house.
called on, they could simply say, well, I'm just bringing this up in the context of the police not looking at this person. then the whole line of Denny case law is worthless. It's worthless then, because there is absolutely no situation where a person making a Denny violation would ever be able to.
Oh my God, the side eye. Nicole, did we just become best friends? Because you side eyed straight on looking at him. That is like, you know, that is a gold tier move of sassy pettiness, and I am here for it.
Be held to account so that the prosecution had proper notice, the individual was not being blamed without the court being a gatekeeper, and of course, all parties had a right to a fair trial. Counsel cites one case to the court. It's Kyles v. Whitley, the U.S. case. That's about a Brady violation. It has nothing about third-party liability or some third party being blamed. I don't believe it.
Y'all, I heard third party, and all I was thinking was intervener here to represent my client. Terrell, you have done ruined third party for me. Yeah, I would assume that the first person that you would talk to would be the person that found the body. But again, I am only a lay criminologist, so
Has any cogent or helpful analysis for the court, but the Denny case is absolutely clear. It asks for pretrial guidance for a judge when an individual has been specifically blamed. Again, Judge, this cannot be put back in a box. There's no corrective instruction that will allow us to correct this. This is why the Denny case is a case that stands for pretrial or before being brought up in front of a jury admission of this sort of evidence, discussion of this sort of evidence. It's so we don't get to this place. You can't give a curative instruction saying, you remember when there was that sown sort of theory of why the person who discovers.
Sir, look, I'm not trying to be all religiosity on you, but people with sewn cases shouldn't throw stones. Like you're, as I'm hearing spoiler alerts, your case makes no sense. You expect on both hands, both things to be true, which can happen, that Zach is both a super spy that was able to GPS and hack the phones and be all NSA spy big brother with Sadie. Look, y'all, just let people go. I mean, I'm not alleging that Zach did this, but if you have to learn how to technical stuff, there are plenty of fish in the sea. You don't have to learn tech. And then also at the same time, be dumb enough to get his El Murder, kit from Walmart where, self-checkout. It just, for the love of all that is holy.
This bloody scene is actually involved in a conspiracy to kill him and frame the defendant. You can't take that and ask the jury not to consider
I've seen
that.
Lifetime. I'm just saying.
I don't believe it is a legitimate theory. I think if the court hears us litigate this, you will not think it is highly that it is relevant material to make an accusation that there's a frame up. But we don't have an opportunity to investigate that in short order, Judge. We will need an opportunity, as Denny is supposed to afford, to be able to take a look at this allegation. And at this point, Judge, I suspect there are more of these. And I suspect the careful litigation of this case now is to ask the defense if there are any people they intend to specifically blame in front of a jury, either in opening or closing or during the course of this case, could they please in pretrial motion present that so that the parties can litigate all that matter together. Judge, I believe that's the only course that is allowed. I think there is a manifest.
Okay, so why is it that Wisconsin is the only state where the defense doesn't get the full benefit of the doubt? Writing that down for David. I love that I can read my own terrible handwriting shorthand, but it seems rather prejudicial in my mind, the way I would think about it, that the defense can't explore any and all relevant avenues. But, yeah, it's y'all, I'm just saying, if you're gonna go to all 50 states, skip Wisconsin. North Florida will try to get you. They will try to catch you a case. Stay the heck out of the murder mitten, all right? You know, and you're not gonna use some Clorox wipes. Yeah, I would think that that would be
Injustice that's been
something that would
determined
be
here
brought up.
by this argument, and I ask the court for a mistrial based on this finding, and ask the court to then discuss the speedy trial and how this is an exception to the speedy trial demand by the defendant.
Well, during the break, I reread Denny and some of the other pertinent cases. But along the way, I encountered a case which has not been published. It's not recommended for publication. It was released by the First District Court of Appeal, well, by the Court of Appeals. First District case. And I'm going to be careful about citing it because it's unpublished and it's not recommended for publication.
Yeah, knowing what we know now, I'm sure Zach would have wanted, to take a mistrial. Maybe, I don't know. I haven't talked to him. I have tried to stay kind of out of the current stuff happening so that I can kind of look at this as unbiased as I can with, Gravely being a dill hole. But, okay, so they had to bring this to a judge because there is a Denny ruling, and let me see if I can pull the Denny ruling up. Well, we might do that in a shorter video, but it looks like that the Denny ruling, in short, requires that the defense, if they're going to try to put forth an alternate theory that has a particular person named, or they have to bring it up to the prosecutor because they have to be able to all be on the same page. From what I've gathered loosely, I am going to be asking, I'll be looking it up. I'll read the little thing, and then I'll ask the lawyerly people. Yeah, that is the other thing that I noticed, just right off the bat, the physical, and it seemed like almost the personality shift in Judge Schroeder from Rittenhouse to this trial is profound, and I am surprised that they are not getting sued for potential judicial misconduct because you have a judge who is compromised. Yeah, I mean, he is a good, person, and I liked him as a judge, but the fact is he's a compromised judge. If they didn't trust him with criminal cases and they had to put him down to family court cases, which should be just as important, if not more important, because they're more common, I would think, and you have the lives of families. I am worried that a lot of his decisions are gonna be overturned, kind of wrecking his legacy. They did have a mistrial the first time, in this case. I believe from what people are saying in the chat, the state bungled things up. Yeah, it just seems like it seems really kind of slimy all around. So I hope that things will be set right and we will have the impartial justice system. But this is sad. It's like watching your grandpa and seeing him decline.
Publication, but it raised some interesting issues to me, quite apart from what the court said. Well, I'm going to cite it for historical purposes, not for precedential purposes. Some evidence came in. It had already come in when the Denny issue arose. The judge felt that it was Denny type evidence. And said it shouldn't have, the DA hadn't been properly noticed. And
Well, I mean, at least things stay constant.
granted a mistrial. And
here's another thing I'm going to ask David, citing to this case historically, but not, as precedents and, making his decision. I'm pretty sure from what I've understood from Rackets and all the other legal minds that the judge is somewhat like God in his own courthouse. But I would think that this would be something that's bordering on a very easily kind of overturned thing. Bringing up a case that wasn't published. It's all the shenanigans.
there's some discussion in there about what's a manifest necessity. It's quite interesting. There is also the history of the case. The judge did grant the mistrial and ordered a new Denny. Well, it ordered that the defense wanted the evidence and they needed to bring a Denny motion, which the judge heard and decided that the evidence was proper Denny evidence. Now, we talked before the break about the high-risk strategy, and it is indeed high risk. And especially if the judge ultimately determines that it is appropriate Denny-type evidence. That cross-examination, because, and I know you're making the claim that this is directly the target of the Denny rule, but
This is a strange sort of talk because in Rittenhouse, I remember him being almost to a fault lenient about bringing stuff in. I don't remember him being so much on the defense side, but okay, so Jen, I believe this is what Schroeder has done, or Schrader, whatever his name is. He did this in the Rittenhouse. He would start off and you would think, okay, he's going to rule one way, but then he would keep talking, kind of go off into a tangent, and then come back and say the exact opposite in his ruling. So it's really, really strange. Yeah, I'm going to try to get with David and see if he has time to do a stream about the Denny rule. I know that this is, I think, specific to Wisconsin. So he might not know all the ins and outs, but he might be able to point us in direction, or if he reads the statute with us, he can kind of explain it, because Lord knows it's probably with like hitherto for in on occasion. So yeah, I noticed this in Rittenhouse. He would start one way and you think, okay, well, he's going to rule with this. Then he kind of takes a little tangent and then he comes back the other way and you're like, the hell did you get this way? Yeah, it really is.
either way, if it's relevant examination on the subject to which Mr. Ober had cited Kyle's case. And actually, back there's an 18 think 91, or a decision by the United States Supreme Court about the defense right to suggest that the police investigation was shoddy, is the word he used, and has been used at that level. And I certainly not embracing that.
I will definitely
that
talk
it
to
was
David to see
Not
if
a satisfactory.
this is something that he wants to do a stream on, because like I said, I will do my digging, which will involve like Googling and then, with dictionary out, try to interpret what it says in, legalese. Yeah, I would love to listen to him tell me about, the craziest things he saw in court and the things that have made him laugh, and, grandpa tell me another story. I don't want him just determining life and death. I really don't. And
From
I
the
wish I still
standpoint
did.
of proving beyond a reasonable doubt that the defendant is guilty. So I'm going to repeat that this is really very, very high risk, because if it turns out, as I said, that this would be legitimate questioning, quite apart from what's been stated at opening statement. And a mistrial is granted over the objection of the defendant. It is, the case is likely over. Likely over. And as far as opening the floodgates, that actually is discussed. And it has been in cases before. In fact, I think it was discussed in the Denny case. But the state can file a preclusive Denny type motion or a demand for some offer of proof. And
Daryl Brooks.
rattle the cage a little bit to get the matter determined pre-trial. And so the burden is not entirely on the defense. I made the comment before we broke.
I feel like he would be better if, and this is how I operate, I don't know how you guys operate. Well, Brooks' lawyer was Brooks, so he was kind of an ass. Hello again, Taste the Venom. I feel like Schroeder would be better in, like me, where I have to sit and I have to settle with my thought, because first you're going to get my hot take, then you're going to get the 8, aborted trains of thought that I have and the nebulas attached to those. And then I will finally come back to a cohesive statement. So, 5 minutes alone, talk this out in your head, then come back with, your your first little, your not hot take, but your full take. Oh, Judge Doro. She had nice hair. I'm just gonna say it. But she let he is like a daggone toddler. You tell him no, you put him in timeout, and then you do not shift course. We do not give in to terrorism, toddlerism. No, no.
That, and I'll stand by the comment. And I made my ruling on the Chapman?
Campbell.
Campbell.
Michael Campbell.
I didn't feel that the defense had presented a strong enough case
So am I.
of
And we gave our
legitimate
last 3
tendency
G names,
The,
so we're always confused.
as it exists in Wisconsin. This is paragraph 12 of, we didn't cite the cases that way in those days. Well, yeah, I guess it is. It's page.
Wait a minute. Okay, so again, why are we using a historical non-published case to come to this nebulous reasoning that the state or that the defense didn't prove enough that, there is likelihood that sometimes people that find the body are in fact involved, if you
12.
will.
Thus, of the Denny case, in the Callahan's reporter, thus, as long as motive and opportunity have been shown, and as long as there is some evidence to directly connect a third party person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible. By illustration, where it is shown that a third party not only had the motive and opportunity to commit the crime, but also was placed in such proximity to the crime as to show he may have been the guilty party, the evidence would be admissible. Or where a third party has committed or actively seeks to commit violent acts
Thanks for that,
against
John Gary.
the
Was that the
victim,
first
or has
mistrial
threatened
then?
the victim in a manner not remote in time, place, or circumstances, evidence might likewise be admissible. Yeah, I commented last week, I didn't think that the Campbell, thank you, case,
Okay, this is slightly terrifying. I mean, look, I am bad with names. Look, I just touched the screw thing. Y'all, I am looking for a lapel pin, or Mike, I'm telling you, Amazon Prime Day cannot come quick enough. But the fact that he can't, you're the judge. You are supposed to be, I mean, we saw Judge Doro. She wrote like 18 notebooks in the Brooks case. The fact that you made a ruling and you can't remember the name is very, very concerning to me. I mean, I expect more from judges. I'm sorry. I expect more from lawyers.
met the standard, from what I've heard so far. And this is not a ruling. This would be a much stronger case for the defense.
Yeah, I maintain a high degree of confidence that the court's mind will change when the court hears the circumstances, but that will be,
That was the mistake that
Yeah.
I'm not commenting for presidential purposes, but that was the mistake that the very good judge in the case from last year
Well,
made.
I know, Julio, I know, but what I'm saying is if I had someone's freedom and life in my hands, regardless of even Schmucky McBorder guard guy, I would take detailed notes because this is a person's freedom and I want to be on point and use all the highlighters I have. Y'all don't know I have an office supply addiction. It is sad. It is sad. Sal, I know, sadly true.
I even though that mistake was made previously, I maintain a high degree of confidence that when I have an opportunity to appropriately investigate this, and the court hears the factual circumstances of this scenario, just as the court did in Campbell, the court will find this to not meet the standard of Denny. I have a high degree of confidence of that the court will not find a motive.
If I'm understanding this correctly, the state is going to investigate itself and find that the state did awesome. Seems like well, he would be confident, wouldn't he? Oh, I know. That's what I'm saying. Yeah, I have ADHD. Now, I've probably had it my entire life, but kind of just always did the hummingbird grasshopper kind of hop to the one thing to another, but it's gotten really bad since I've had 6 kids, mainly because when you have little children, you can't have a thought on your own. Well, I mean, okay, linear thoughts, which were already an issue for me, you may or may not have. Okay, so I am what we call a positive starter of notebooks and, planners, and I have half-finished planners everywhere. I always intend to be less of a hot mess in the future, and I'm always currently the same hot mess I was, previously. So at least I always have optimism, but it hasn't quite stuck yet. Yeah, I mean, listen, I'm going to be very honest that in my personality range, I would never be friends with Gravely. I don't care for his style or his cadence, as a personal choice, but I'm willing to listen to what he has to say. I just wish he didn't say it the way he did.
And will not find circumstances that are worthy of a jury actually hearing that accusation made. And I fear that there are additional candidates for Denny consideration. And so, yes, I intend now, I evidently was fooled by the idea that a Denny motion was filed against one individual. And maybe that is my error. Maybe I should have understood that when defense counsel chose one person to file Denny and then made Denny arguments on another person, and I believe intends to do additional based on the representations they made previously, I didn't know that they were only going to litigate one and not others.
Well, I'm not suggesting you did commit an error.
Well,
Oh, for all the Eddie Haskell bullshittery. Well, Mrs. Cleaver, you look so nice in those pearls and doing the vacuuming in high heels. You're just so awesome. Of all the smarmy, if y'all have ever seen Recess, from like the early 90s, the cartoon, this dude is a total Randall. Miss Finster, they're doing it again. Something in Recess. I hate that. I hate smarminess.
But you did not, we're not on the same page. No.
I've never filed that, never filed a pre-Denny because I've never faced defense counsel.
Apparently, in his understanding, you do need to file a Denny for everyone, and I will find out more with David. Yeah, I look, if he has evidence, I'll go where the evidence takes me, but smugly. He is both ugly and smug. And I do not like smugly. Oh no. No, ma'am. No, sir. Jesus does not like smugly.
Before where I felt that was enough of an issue that I would, but I certainly will this time. And I certainly adopt the court's idea that in certain circumstances, when certain things have happened, that the state has an ability to force this litigation to occur. So I'm going to do that. But Your Honor, we are in the same boat here. I don't know who will be the next argument that is made. This is an argument that cannot be taken back from the jury. I am requesting a mistrial, an opportunity to do the appropriate Denny.
Okay, well, I guess here's my issue with the whole Denny motion thing. And I'm sure, look, I don't live in Wisconsin. I didn't vote for whoever made the Denny motion. But to me, it seems as though everything is supposed to be, from what I've understood, during the court case, seen as if there is even slightly more weight for it to be on the defense side during the initial trial. You are supposed to give that weight to the defense. I don't know. I don't know what precipitated the need for a Denny motion. Maybe defense attorneys were being really super duper sus and, saying like aliens and, ninjas like Jody were doing stuff. But yeah, they just say, I don't know. Yeah, okay. Like I said, I'm waiting for the text messages. So if the text messages are sold, I will
Investigation and have
look
the
at
appropriate
those.
Denny
They're not
motion
sold,
filed,
shown.
and then let's litigate this.
Judge, if I may.
No, Judge, we can't have multiple attorneys.
Well, my feeling is the reporter can decide if, sometimes it's just a constant barrage of remarks coming from one table or the other. And the reporter can't be expected to handle that. Where it's segregated enough, with
It's not fair. They're gonna use 3 people against me. I sorta get it, but not really. Again, everything should be on the way toward the defense. He is presumed innocent. They are vigorously defending. I don't know. Yeah, I mean, that seems like a relevant thing to say, but who am I to speak?
this present a problem, do you have another lawyer address this? Okay, go ahead.
Thank you, Judge. And I'm not trying to barrage. I've been quiet as a church mouse, as you saw. So, so Mr. Gravely's wild imagination about all these Denny motions
You
that
can
are,
have the adjective in there.
I'm sorry?
You don't need that adjective?
Okay. The imaginative discussion about this
Uh-oh.
motions that he thinks is coming is it's a little bit mind-boggling because he now says that after hearing this text that we got from him, Judge, that now he wants to go investigate, and then he's confident that he's going to prevent a Denny motion or defeat.
Why didn't they investigate beforehand? Why does it seem like they're waiting for Denny motions to come investigate people that could be suspects? Again, this shifts regardless of who you are, this shifts the, burden to the defense. I am waiting to see them, and I will try to see how I will let you guys know how I interpret them. I just sorry, feral children, and we are trying to discuss who is going to have to turn off basement stuff and who is not going to have to turn off basement stuff. So,
One.
yeah.
Well, we've made it clear we're not doing a Denny motion. We're not doing one. If you read this, the context of this transcript, it is Ms. Mueller saying the police investigation's poor here. They missed this. They missed this. They missed this. And then she talks about the transcripts. The texts. And so, and if you remember, Judge, during our last trial in this courtroom, it was the state that suddenly had some information that would come out during his opening that we found out about. That's what caused the mistrial then. And then following that, with quite a bit of litigation to follow, they did their investigation. They followed up on that investigation. So it's the same refrain right now that we're hearing from the state's table, the exact same thing, that they're caught flat-footed about stuff that they should have known about, and we're calling them out on it in our opening and in our argument. And that's what this whole case is about. This isn't about 10 different Denny motions. If we wanted to bring 10 Denny motions, we would have brought them. I think this court has seen that this defense team has been absolutely meticulous about bringing things to the court's attention, about litigating things properly. There's no misconduct here. There's nothing underhanded, and there's no attempt to bring a subvert Denny motion. And the accusation, it seems almost like the state wants to take this case because they know that it's weak. That's what it looks like from the defense table. So I'm going to ask this court to deny the motion, instruct the jury to say, just like Mr. Robert was saying, to say opening statements are not evidence, period. Okay? And then we'll finish our openings and we'll get on with it.
The particular problem for me, one of the particular problems for me is, and I'm sure I commented about this before lunch, is I certainly agree that it's our law, and it has been for a long time in this country, that the defense has the right to pick away at the caliber of the police investigation. And some of the points that have been raised by Ms. Mueller have been along that line, and this is certainly one of them. At what point does the camel's back break? At what point does legitimate picking at the caliber of the investigation become an accusation of another? This this would not be this big of an issue in the case if this just arose during question and answer of a witness and there being an objection, and then I would have to make a contemporaneous ruling, and we might never even think of it in terms of any type motion. But unfortunately, I understand your position, and I wish this weren't arising now, but there is a point at which the additional weight of the additional issue created by this messaging, along with the features that go with it, could or did break that camel's back. And what do I do when this issue arises in opening statement? Do I say, if I think that this evidence is going to be admissible, do I rule without considering its cumulative effect, which maybe deciding it is Denny material, and that's what you claim, because you say in the end they're going to be pointing fingers and citing all this evidence, and I can see your point that it becomes Denny type evidence, or I can hear what the defense is saying, and just let it in as evidence to support their claim that the
You know, that I guess is my stance. I don't really care so much about the text messages. If they stipulated to the text messages not being talked about until it was on cross, maybe that could be a remedy. Or for the judge to say, look, it's not argument, what have you. But again, she should have been investigated because she's the first person on the scene. Heck, we are seeing it in the Theodore Edgecombe case with B. Ivy Lamar. She took his doggone wallet. She probably turned over this 250-pound man, shimmied a shank into his pocket, while leaving no blood and nothing on him, and was able to plant and send an innocent man to prison. If it was okay for them to do that in the Edgecombe case, to bring up, maybe they filed a Denny motion. I don't know. I'll have to look into that. But it seems like the only thing that was done in the Edgecombe case was to question the police, investigation, qualifications, things like that. So I have a real problem with different standards being upheld differently in different courts.
investigation was not properly done.
Well,
Now, here we are, because it arises now, we have this big issue right at the beginning of the trial, and the jury's been told you have 2 weeks, and maybe an extra 2 days beyond that, and we got to get this case done. And I think, well, if anybody is talking about adjourning this case for more than a day or so, the answer, unless you have some compelling reason I haven't thought of, is going to be no. I have no desire to mistry this case, and because I do think that taken individually, and as I think I commented yesterday, or maybe in the motions last week, you people, lawyers in general, come to court thinking that the judge has this enormous wealth of evidence, knowledge about the case, and that is very untrue. I don't doubt for 1 minute that every one of you has 10, 50, 100 times more information about this case than I have. Judges very seldom see much before the trial starts. So you say this is, you suggest that this is all going to be easy to destroy, these points that the defense is raising. Well, I don't know that. And and then it's all going to turn into a massive Denny type attack. I don't know that either. So I have to make rulings on, is this legitimate?
I again feel like this would have been better for him to, in as much of as he was able to have the capacity, to go back, gather his thoughts, and then make a ruling. I feel like Judge Schroeder is always swayed by the last person that talked, or he tends to boomerang around. And it's hard to get a feel for what he's doing with the court. You know, it might be that way. I don't know. As far as I don't want to make an opinion about that, John, until I talk to David or Nicholas about the Denny rule. And I think no offense to Nicholas, but I know he's really in the middle of a big case that he's kind of, I don't know, finagling, lawyerly word for, hammering out the details. So I don't want to add any more to him. And David might be able to do a quick old stream and, in the US of A, even though Nicholas would try, he might know exactly where to look for how the whole Denny thing came. Yeah. Like I said, I am not sure. That's why I'm gonna try to find out for you from a legally lawful law lawyer what the Denny actually means. What the Denny means. Now I really want Denny's, which is low carb may kill me, y'all. That's all I'm saying. I understand that he talks and thinks out loud, but what I would want again would be a clear, concise, cogent sort of understanding and ruling. His rambling I lose focus. I need him to.
Inquiry into the caliber of the police investigation. And
So, can I just say,
Yeah.
Ms. Jagle, the person who's texted back and forth, is on the defense witness list. She's been served by the defense. So this is not just an innocent kind of, well, why didn't the cops do this inquiry? This is a subpoenaed witness who's on their witness list. There's no other reason that I'm aware of that she's a witness on their case. And Judge, I didn't object.
Maybe.
well, why did you think she was on their list?
Well, because they have subpoenaed 150 people, and because of those 150 people on their witness list, this is a dear friend of hers, and but they have not spoken to her. They've had no conversation with her about this case. They have, my understanding, again, this is anecdotally, is when she asked why they wanted to talk to her or why they wanted to subpoena her, they did not provide information regarding that. Judge, I did not object in this case and say to the court that I needed to object based on Denny until point number 5 of this transcript came up, which is drawing the line the full circle. So said, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And then the immediate answer to that is, what's 1 week later? That's when she's at Gutierrez's apartment. So it is a suggestion that goes full circle from beginning to end. And Your Honor, I believe Your Honor is presenting the parties by saying, yes, a Denny motion should have been filed. I think the court is saying that. I may be misunderstanding the court. And there is no remedy at this point for the court. I'm not asking for an adjournment, Judge. I am telling the court improper information has been provided because the court has not heard this in the way that Denny intended. And it fits all of the qualities of Denny. This is not just something that came up in the middle of trial under somebody's questioning. This is a deliberate presentation. This is an argument structured by a lawyer that began by saying suspicious person, first person to discover Rosalio Gutierrez's bloody crime scene, text with her, conversation with her friend or dear friend on our witness list, turns out, and mystery.
Okay, but from as far as I can see from other cases, I mean, so the Border Patrol case, I believe the defense had like 30 witnesses that they would on their witness list. They called one, and that was a rebuttal from the state's medical examiner. I am already starting to get irritated.
It's been taken care of. Call me in a week. And then guess what they say happens in a week? She shows up at the apartment and finds the crime scene. She's described as a conspirator.
I've already stated that I thought this is
So,
This was a stronger case than the case on which they did bring the motion.
but the court has not heard the Denny criteria. The court has heard one very specific set of facts without the state having any ability so far to respond.
Okay, call me crazy. Just don't call me Shirley. But if I were like in charge of a case, I would have all the information on at my fingertips, a whole file for each witness, and I'd be able to say, "Look, we have the file right here, Your Honorness. Sadie was here, here, and here. I can show you where she was. I mean, she was being a hot mess, but she was here. Like she was at the Walmarts. She was buying the vodkas. It is what it is." The fact that they have to go back and investigate, it does not bring confidence in. I believe, the sentencing, I would have to go back and I didn't really watch it, to be very honest with you. So I believe he would be about 89 before he got out, with all of the okay, thank you very much, chat. This is the same thing that Binger did. He kind of almost ordered and or yeah, it just John, I get that you have a very big opinion about this, and I am trying to be as open as I can. So I will take all of this into account. Dennis, I knew someone was going to get it.
That's where, no.
Okay, and
Here.
the court is.
No, Mr. Grable.
Oh, hells no. You do not tell Mr. Don't Be Brazen with you don't keep talking when, Judge Don't Be Brazen with me says no, 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 no.
This is the mistake that the very capable judge in Milwaukee made that I've mentioned. Should have waited till the smoke cleared. You made the statement before, there's no other remedy. That's not true. Some of them are not remedies I particularly want to do, like telling the jury, guess what? Your plans are all off because you have to sit home a day or two while we deal with some legal matters that have just come up. I investigation and resolution have got to take 10 days or 5 days. And we squeeze it into 1 day. And I don't think it's outside my power to command the defense if they have any
Okay, I don't know if I'm doing
that they need to communicate them to you by 9 o'clock tonight or something, and save the trial. I think that declaring
is Sadie bilingual or it she seemed to be, and look, I mean this with no disrespect and no any sort of isms or phobias, but she seemed very able to communicate if English is her second language, at the sentencing from what I can remember. It just, yeah, it's
I think ruling this a mistrial on the basis of what's occurred here, without knowing whether this will ultimately all be determined to be admissible, which is one of the mistakes that my friend made,
oh
and
lord.
making a determination that something was a manifest injustice.
Okay.
When
Wait, this is a totally off topic but do you remember when they found out that I think it was the New York mayor or someone, but they had a fake sign language lady, like their sign language interpreter was without a doubt like completely faking it all to heck. I will pull up the story. We will do Mo short video. That's fine too. I know that I sometimes hear better with headphones. I was just trying to get all of the information for my. Okay, well that's good to know. I was just wondering if maybe there was a reason if she was bilingual or something like that. Oh, okay. Well, that's a niche subject, but we need people to do it, so okay. Listen, there have been times that it might have been my first and most fluent language, so no shade, because sometimes I am. Okay. Yeah, and it might be easier just to hear with the headphones on too. I know sometimes I get distracted. I know y'all are shocked with different sounds and things, so I like to put my earbuds in. I know. I would be in so much trouble.
There were other things that could have been done. I think that's a mistake. So I'm not asking that you agree with me or change your mind about anything, but I want to hear from both sides here. Without ruling on the pending objection, I'm thinking in terms of sending the jury home until Thursday. Today's Tuesday, right? Thursday, and then we'll pick up from this point, and at that time, I'll either sustain or overrule your objection. And me direct Ms. Muller to move on to another subject. We'll have, I've already canceled or in the process of canceling what was left on my calendar for tomorrow.
So,
And so I'm available to hear these things and determine them. And then I won't get in the boat that the poor judge in Milwaukee got into.
so
Well, if I could, Judge, I think,
Well, yeah, you did speak first. Go ahead.
yeah, I guess I'm a little confused about what it is that the court is going to wrestle with in the next day. Because if it's, well, I'm going to listen to the defense's Denny motion, there is none. So,
Constructive Denny motion.
sorry?
Or do you prefer virtual Denny motion?
Okay. All right. Well, if that's the case, we need a week. I don't know, but
Well, you're not getting one.
I know. So what you're saying, this is, I just want to understand where the court's at. You're saying you want to have a hearing on what was said in opening in the greater
And this
context.
goes back, John. So when you were saying that he thinks out loud, this is the problem that happens when you think out loud. Believe me, my husband's like, okay, so he's learned to like let me just kind of babble. And then he's like, okay, do you have like a solution now? I was like, yeah, I've actually come up with a thing. But for a judge, you need to have all of these things, in my opinion, all of these conversations with yourself and going through the law and having your fun little stories. Look, I tell myself stories all the time. I crack me up all the time. You need to have all of these in your inside voice. And then when your outside voice comes out, you need to be clear and coherent because these lawyers are like, I don't know what he's saying. As a judge, just if I were going to be a judge, that's the process I would use because I know me. I know I can get on tangent story time. So I would go back to my room, have my little talk with myself, read all the books, do all the things, and then come back with a cogent, story and decision. And then I wouldn't let the attorneys talk anymore because I am in charge. But God does not grant me power because he knows I would do it. I would use it for evil. Just like Judge Schroeder is looking a whole lot like Emperor Palpatine. I'm just saying.
Context of what the actual evidence will be.
Well, what was said at opening is significant only because it creates,
And John, I get that. I get that. But when you're making a ruling and you come to the end of your ramble and no one knows what the hell you're thinking, or at least I don't, then I find that to be a little problematic. But like I said, this is my opinion. You're here listening to me ramble, so it is what it is.
the problem that I was discussing at the beginning, that this is.
Okay,
time
is
for
law
something
and
that needs to
crime
come
having
up.
like a
And
stroke?
that's really not the focus. I mean, if there's a misstatement made at opening, it can be dealt with, whether it's by a corrective instruction or whether it's by a mistrial. Made very clear he's willing to run the risk. The issue is, we've painted this portrait of what he thinks is unquestionably any type of evidence being used for the very purpose that the Denny
Hey guys.
rule, what's the terminology that they use? I read it before. Legitimate tendency.
Well, and here's my problem again. I mean, had he gone, stopped, collected his thoughts, he would have had these at his fingertips. I write down, bullet points. I mean, I have mini scripts for things. And I'm just playing around on the ninja net, to be very honest with you. It is a duct tape, prayer, and holy water sort of production around here. But even I take time to organize my thoughts so that they come across clearly and you guys can understand at least what I think I'm trying to convey. I mean, that's what I expect from a lawyer.
Ultimately, I need to make a ruling whether you can present your Denny type evidence in either as a full Denny attack or in some truncated fashion as proper cross-examination, but not suggesting an alternative actor to the jury.
And that might be the way that he's protected himself in the past. I'm just saying, for me, stylistically, if I were going to be a judge, that's how I would do it. I would write down sort of my reasoning, and then I would have a quick, cogent, well, not quick, but a cogent, very, linear sort of way I came to this. Just so, because I mean, these lawyers are confused as to what's going on. They don't know what's happening, and that shouldn't be at the end of your
So that's the
rambling.
big
That
question,
shouldn't
and
be
that's where I said that's where my friend straight is.
how you feel.
He declared the mistrial before he had the Denny hearing.
But Judge, why would they file a Denny motion when they've already accomplished what they wanted to do? The jury has heard this information. Again, this
So
can't
if I decide that the Denny motion is granted,
Yeah.
then they're going to do exactly what you most fear, is they're going to present an alternative actor.
And that's
defense.
fine. I'm just saying, stylistically, for
I
me, I would prefer
say
the
that
other.
they are,
But
that the evidence does not support what you claim to be an alternative actor theory, then, as I said, they're either going to have to eliminate or truncate the evidence that they were going to offer that would constitute a Denny type defense.
oh my Lord, are y'all kidding me? Look, y'all, recovery addict can work all the bells and whistles, and I am insanely jealous that he's able to figure out all the technical things. But boy, does he like to chat. And I'm usually never one of those people that's like, I'd like to hear the court case. But he has such a big crowd that it just was not my jam. He does a great job.
Okay, so what has been
But feel free to say, I don't know what you're talking about.
Well, I'm trying to figure out, so I don't see any motivation for the defense to file a motion. I think they've clearly stated they don't wish to or intend to file a motion. I guess I could file something, and I think the court is telling me that I would have a portion of a day to provide the court a response. I think that's the guidance. If I understand where the court has
Yeah,
told me we're
if you
going,
guys want
and
to
that the outcome of
donate,
this,
I
when I have
am.
requested a
So let
mistrial,
me.
is that
Any reason to pause this man when he's talking? If you want to donate, my Cash App is right here. I am looking to get one of those cameras that zoom in, zoom out. Because I have to be just like David, my idol. But since I've got the murder board, I was gonna put that in there. I'm still gonna, y'all, seriously, for cereal. Um, Prime Day is coming, so there is no obligation, and things are now tax write-offs, which is awesome because I'm getting all the stupid T-shirts, and Mr. Mo is like, "For seriousness?" And I'm like, "But it's a tax write-off. I need business attire." And, shirts with the curse words for office attire and telling the government that it's a tax deduction. I mean, my little heart is happy.
there would be the court believes that perhaps some cautionary instruction would be the remedy, or they would not be allowed to pursue this in other
Okay, y'all,
I've-
this is not me.
Well, the bottom line is this is going to defy any precedential solution. I don't think
That
this
and
has ever
Zydeco
happened
music,
before.
I'm
We
telling
mentioned
you,
that
you play some, or
on
no, y'all know those bowls they do in meditation, the screaming bowls? Y'all want to make me wanna, like, peel off the top layer of my skin? Play one of those things, because one of our pastors once brought it in to explain how people pray and meditate, and I had to leave the room because I was like, "Oh, that is an anxiety machine to me."
the Campbell case, where you couldn't find any authority other than down south.
right?
So the worst to me,
Well, so I am gonna be really and totally very honest with you guys. I am lucky. Mr. Mo does the whole taxi thing, but since we spent a certain amount to get the computer, everything else is a tax deduction. He's really lucky right now that I don't have the zoom and twist camera because he's over here being a doofus on the other side of my camera trying to throw me off. uh, that and Yanni I'd probably give up my secrets. I'm just saying. Thank you, Jungmin. Yeah, I
I'm
used to wear
standing
them all
at
the
the edge of
time
the
and
Grand
make my
Canyon,
own.
and
Well,
I,
listen, this is not Rumble. He is not on OnlyFans, and he was in a towel. Now, I'm willing to, have y'all pay to see that because I'm a capitalist. But he's saying no for some reason. Just like he doesn't want to support my YouTube career. I don't know why.
you're asking me to take the high risk that you are going to be able to knock down this this Denny notice that they've not given, and everything will be fine. That's what happened to the poor judge up in Milwaukee.
And in that case, Judge, just so that we understand the historical reference that I think the court made to us, are you saying that case was dismissed without prejudice?
We will do a husband and wife stream, but preferably not in a towel. Look, I'm just saying, I have 3 teen daughters, and one meticulously, censors what I can put on Facebook with her face on it. So I only like publicly embarrassing her in person, not on the internet.
When I'm talking this secret case, I'm not naming,
Yes.
dismissed
Maybe
with
I'll sign it.
prejudice.
We'll
Okay,
send one
so
by
away.
the Court of Appeals.
Because I've
Dismissed
litigated.
without prejudice by the trial judge.
All right, so I've litigated this issue in our courts here in Kenosha before, had it gone to the Court of Appeals and did not have that outcome. This was several years ago. It was in front of Judge Milosavsky, but I had a case in our county
I'm sure we
where
can do
this
that,
occurred,
'cause,
and not where Denny was granted at the end. So
Mr. Moe and I have been working hard. He's doing more of the workout stuff, and I'm doing more of the eating better thing. But y'all know with guys, it's like, hey, I didn't eat like another Big Mac and I lost 10 pounds. And you're over here like, haven't eaten bread in like 4 years. The heck?
understand that would be the distinction.
Is it
But we're
recorded?
going to be all
No.
smexy by
No.
like 50K.
But
I
it is
just
a
know
case that I had it with one of the Jensen co-counsel from the public defender's office, who still works at the public defender's office. But she, in an opening, did the same thing. But again, I'm not citing it for presidential value. And again, I did not have a post mistrial granting of the Denny, so it wasn't. I think the court is adding that aspect.
Well, if the judge in the case I've spoken of
Yeah.
had not made that determination, I assume the Court of Appeals would have made it for him.
Okay.
Farrell, I know.
What the court has before it right
Double
now
middle
is an
fingers,
offer, what I would call a
deuces.
Denny presentation by the defense,
To all of
where
them.
the theory that is proposed is that this person, from my perspective, what has been argued to the jury, I know the defense says, well, we didn't argue that, we just argued bad investigation, right? But what I believe has essentially what we know
Okay.
points one.
God love him. Zach's face, like, I have no idea what the hell is going on here, is totally my face when the lawyers start talking about something sort of kind of complex and deep, and I'm like, I'm just gonna smile. I don't even know.
Through 5 that I cited earlier is that the idea is that a person who is having an active
I
relationship
totally
with this
agree.
individual, who on May 17th, the very
Like I
same
said,
day
my
that she has
bewildered face
contracted
looks a
for his
lot like
murder,
my your
the day
kind of
before she has
stupid
visited his
face.
children for the first time, and the day of, she is literally texting him, I want to take this relationship farther. I'm hoping we can take this relationship farther. Where in the meantime, she has conspired with her friend to have.
As a pre-body language person, did he just say, "Are you serious?" Swear to goodness, he would be my avatar. Because I would be the worst, the absolute worst person. They'd be like, Mo, you need to calm your face. Listen, I'm not saying that we give you a shot. Do you want to come on? Such a girl. Oh my God. You're not even on the camera.
I know.
Oh my gosh, you're so weird. And I married him.
That was your loss.
I know. I saw the ride, still bought the ticket.
Multiple times.
I cannot with you. I'm the only one that can make a sexual innuendo on here. You know what? I'm looking at several different things. I will try to put David has a wish list, so I will try to get one of those up.
Have him murdered, not because she has anything against him, per the defense representation,
Good night.
but as a means of framing his ex
Yes,
because she is
he did a
frustrated
wonderful
that he
job, and
is
he put
monitoring her
up
in some
L
way she can't
brackets
prove.
so that it
That's
doesn't final
that's the
destination
factual
me
circumstance the court has. So the motive the court would
in
consider.
possibly the most hilarious way. Like, y'all, I'm just saying, if my murder board happened to murder me back, I would hope you would mourn, but also get T-shirts, because that would be the most fun, hilarious thing I'd ever. Like, it would be true Mo tradition.
I'm back at the same place I said before.
Yeah.
I don't have all the information that you do.
Right.
So I don't know.
That's my point, is that I haven't had a chance to make that argument to the court because we didn't have a Denny motion, right?
All right,
where we
that's
would have a
fine. And
pre-trial
I
motion.
told you we can
Same.
have one now. And I don't know what happened downstairs in that other case. And I don't know anything about it, and it's not reported, so.
Sure.
Well,
Um, But let's hear from the
yeah,
other.
just-
Like I said,
Judge,
I will
I-
put up
I don't know how much a
kind of a
briefing or
wish
whatever needs
list.
to be done on this. I think if we print off the entire transcript of Ms. Muller's opening, so you can see the entirety of these very tiny comments.
I would be sad if you didn't, Jungmin. My mom would be like, I don't know if I know. Did we know anyone from Sweden? I didn't even know she knew people. She doesn't get out much. My mom would be all sorts of confused. Look, she doesn't know how to work the YouTubes, and we're keeping it that way.
in that whole larger context, it will be pretty clear that what we were saying all along is that this is just about a shoddy police investigation. It's not trying to point a finger at a third party. We would have, if we wanted to do that, Judge, as you well know, we would have done that.
Well, I have the good fortune that I have a splendid court reporter who came into my office right after we broke and said, would you like me to go back a little further? And I said, well, yeah, if you've got the time. And she presented me with a longer transcript. So I have a better idea. And I was listening, by the way.
Yeah.
But
I think that'll make it pretty clear. In other words, we don't need to have some big factual presentation.
I will say, and look, I know I'm getting on gravely, and like I said, it's just a personal sort of thing about his delivery of things. But I do like the and I will learn their names, y'all. But this particular lawyer and the other one, the other male defense lawyer, I like their way of speaking. It's very calming. It's a little bit satire-y, but not too much. And it's calm and it's sort of like, this is the thing, this is the thing. If I were a judge, if this alternate universe happened and somehow I was a judge, I would much rather have someone speak to me like these two lawyers are doing than gravely. And I understand that just might be a stylistic thing. And it's again part of my personal bias. I don't like to be talked to like that. I don't know many people that do, but then again, I don't get out much.
What's in that transcript. It seems to me that that's going to clear this up for the court.
I'm not going to comment. I don't know what the future holds. I certainly would not have predicted when this day began that I'd be dealing with this issue right now. But consider yourselves as having filed a Denny motion on with respect to Ms. Beecham.
Yeah,
And if you have any others who need to state those, what did I say, 9 o'clock?
Yes.
9 o'clock by message to the district attorney, electronic, and to me. And the DA can.
And another part of the judge maybe having these memory things that may be a personal kind of like, God, I hate this word, but trigger for me is that, since I got diagnosed in the last year with all of the different medications, I don't remember uh, I don't remember things as clearly as I used to. So I find myself, in order to combat that, writing notes, taking screenshots, doing everything I can to stay on top of it. So I understand maybe having a, you know, sort of kind of a leaky cauldron, if you will, for a mind. Totally get that. But, if it's the kids stuff, if it's things I need to be at, I make a point to do several fail safes, and that's just me taking care of the kids. So if I were a judge and I knew how, important this could be, I I think I would have all of those fail safes. That's kind of what bothers me about it.
Have until
Same.
well, we'll start again at 1 o'clock tomorrow. Okay. And I'm not going to put a deadline for you to file a written response. You can just.
We're going to start with legal arguments at 1 or
We're going to
start
start
with the
with
jury at
whatever
1?
anybody wants to say on this issue. And I assume there's going to be a lot of legal arguing, but if you want to offer testimonial evidence, we'll do the best we can.
Listen, I look at my own
So
boobs.
today,
I
I
I
believe the
have
court's
tried to get
denying my motion
myself
for
for
mistrial.
harassment,
No, I'm
but
not.
I mean,
I want to get all the facts.
provisionally.
I
it
wouldn't say that.
is.
Okay.
The cases are
I
always
wouldn't,
thrown
no, I
out
wouldn't say that. I would
for me
say,
talking to the victim myself.
I wasn't trying to cast
No,
aspersion in
no.
any way. I just was trying to interpret how the court is, where the
Like I
court's
said
posture.
before, Christina,
Yes.
I will
Um,
I will be looking up. I'm looking at several different models, and I will put that in maybe my community page or wish list. I'll talk to David. He knows all the technically thingies. And look, guys, it is getting very close to 9 o'clock. I'm probably going to finish this up fairly soon because if you get up at 4:30, 9 o'clock is like midnight. look, boobs are boobs. I mean, look, I'm a girl, and if I see a low cut shirt, Imma look at the boobs too. I'm not. It is what it is.
I have not made a decision
Okay.
on that, and it,
Sal,
And that is what we're
thanks for
litigating in
letting
part
us know.
tomorrow at 1 o'clock. Is this issue of
and
whether,
I assume I'll make
Are you
some
talking about right
decision about.
now, John Gary, or do you have like a specific time and date that you want me to be aware of to look to see if he's flirting? I haven't seen the Dr. G thing, mostly because Mr. Mo will not let me buy a bald wig too right now. He's like, you have 2 granny wigs, 1 golden girl wig for different. I never thought that I would actually turn into the real life, oh gosh, I don't remember Vern Troyer. He was or no, I don't. The guy that played Ernest. He did all the different voices. He was like my favorite character. Um, so it is fitting that what I wanted to be when I grew up was a person that did a bunch of crazy acting, and I made Church Lady, who is a nod to Dana Carvey's Church Lady, but she's more of your fiery Southern Baptist. She's going to tell you how it is. And she will be on tomorrow at 2 p.m. She will. Yes, the 6 kids are evidence that I had nope, adopted 3 times. Behave, C-swept. Well, you know, the 6 kids, the proof is kinda in the pudding at this point. Or maybe we're just really terrible at it. Wouldn't that be horrible? I mean,
Whether we go forward or not, and under what
that's
circumstances,
kinda
and
sad.
give you some guidance about what and would and would not be acceptable evidence out of what has already been mentioned.
so of course, we're going to start having witness crunches, and the court, that's not the court's problem, but it is ours. So am I to have no witnesses available tomorrow? My witnesses would again be available for Thursday? Is that my guidance?
Yeah, because I'm not going to have the jury come in tomorrow.
Okay. All right. And so we will litigate my motion for a mistrial as well as the Denny
Chad,
issue
as
at 1 o'clock
you
tomorrow.
were
Do I have
awesome.
that correct?
And if
guys-
anybody has
You guys feel
a
free
witness who's
to
absolutely, positively,
be as
has
inappropriate
heard
as you
tomorrow,
want. You know that
tell me
that's
that
why we
right
are
now.
here.
because it's not that I can't have the jury come in, but at this point, it doesn't seem there's any sense of it.
So Michael Campbell is a witness
I loved
who
Roseanne.
is headed to Florida on a planned vacation. You remember Michael Campbell? We've mentioned his name a few
Yeah,
times.
I've heard his name before.
So he is headed for Florida on a pre-planned vacation. He's leaving on Thursday to go on that vacation. I've just asked if we could figure out when he gets back. I don't know if we know that. Okay, so we're checking to see when he's back. I don't know how long it is. He's the only one I know is an issue for Thursday on.
You guys, y'all are my best friends, and we hide our trauma and the hard cases under terrible, terrible, terrible humor, but it works for us.
Yeah.
And y'all, can I praise Zach just for 1 second? And it's nothing to do with guilt or innocence, but the border agent case and the doggone Courtney Clenny case, this man is the first man that has had a man bun, and it's not covering up a doggone giant bald spot with like 2 pieces of hair that have been grown 12 feet long. I'm just saying, it's not covering a bald spot. We salute you, sir. I have a grave issue with it.
If I could inquire maybe like when that transcript would be done? If that would be done, so we could work on it tonight, tomorrow? Perfect, thank you.
You don't get service like that everywhere.
No, you do not.
Is what, Sunday? So he'll be back next Monday.
Sal, I now demand that you start growing a long mane of hair simply for my amusement. I am a semi-professional YouTuber. I believe my whims are now law, I'm sure. I I don't know, is that how Nick Ocado does does things? Look, y'all, I just joined Twitter, and I don't even know if I'm doing the doggone thing right, so I do apparently, I have the power of freeze frame. Good lord. That was an unfortunate pause if I've ever seen one.
Based on where we're at right now. Okay, so we have a witness who will be gone physically Thursday, Friday, but he's returning back to town by next Monday. He's the only witness that we know is an issue for Wednesday.
Okay.
D
Defense, any witness issues?
You know, contrary to popular, trial behavior and not wanting to be in a trial, I'm gonna just try to not marry and date. I mean, now I am okay with a brother husband, Mr. Mo is not. So, we are working on that. I keep trying to sell, like, that he would only have to take out the trash twice a month instead of 4 times. Uh, we will let you know how it works. I'm telling you, TLC is going to syndicate us somehow or another. Yeah, I have no idea how to Twitters. I'm getting better at it sort of, but listen, y'all, I'm gonna be terribly honest with you. I have many, many thoughts, and the minute I start thinking that the world needs all of the random thoughts in Mo's head beyond, like, certain streams, I feel like that I've gotten way too much of an ego. So, I generally just post, like, videos that I'm gonna be on until I learn how to do it.
Sorry, I just wanted a clarification on what exactly the court was ordering the defense to provide by the state. And I'm assuming it was by 9 p.m. or 9 a.m. tomorrow?
It was 9
Um,
PM.
Okay.
And it
Christina,
was,
I've posted
any
my Cash App,
persons
and if, any of the moderators will put that in a link,
where you
and
propose to
she can do
offer
that, thank you. That would be very
alternative
generous. It's very
after
appreciated. It's
evidence
never expected. Look, it
in
is
terms of
y'all, food is expensive. Everything is doggone expensive.
death of
So,
Mr.
thank you so much.
Gutierrez.
Uh, Believe me, no one knows it more
State
than a
says
person
there are all kinds
that's
of people. I have to tell you, I
trying to
deal with
feed 6 kids.
a lot of people with bad reputations coming through here over the years. And this is a first for me to have that many people who would be considered as, you said there were going to be a large number of people who are going to,
I thought I heard a representation. I was basing that simply on the defense indicating that they had some more people that they were about to make a similar argument at the point that I objected. It was just based on the defense, I believe, indicating that, and the track record of Michael Campbell indicating that we had a motion, and then this
Let me
case
see. I've
where,
got
from the state's perspective, to accuse Sadie of being a
Uh,
suspect in this homicide.
yes, let me double check.
Counsel discussed what he
Y'all
felt was
know I
mind-boggling. This is my
only
mind-boggling episode.
rarely
So it dramatically increases the number of people who I see as potential
It
suspects.
is amazing,
That is the quality of
the
the
things I
theories that
have
are being
learned in
provided
just
to the
a
court,
short
or
time,
to a jury. So I rhetorically
doing
said that it appeared to me that there were a number of others, but
YouTube.
I may
I
be
can't
wrong. They
believe
may provide no additional individuals, which would be fine.
So what it sounds like,
I'm
the state would like to take all of the points of the investigation dealing with particular individuals and reframe those all as Denny and get you to exclude them so that they don't have to worry about them. That's what I'm hearing. Because Mr. Gravely keeps saying how we are accusing her, and we've repeatedly said here in open court
so
that
Gigi,
that's not the
it's Mo in
case.
the Deep.
So
I didn't
you
put
could have a
end on there,
reasonable,
so I put the
we could look at this
correct
transcript
one.
and
Thank you
the
so
court might
much,
read it one way,
moderators,
Mr. Gravely might
for
read it
doing
another
all
way,
the
you
linky
might read it one
things.
way. But at the end of the day, there's not, he can't just ask this court to look at every single point of criticism of a shoddy investigation and call that Denny.
without
Not the case.
responding to your comment, I would just say
And,
that if you do not
1
supply
second.
the state
Thank you,
with the
Josie,
information about
for
people
the donation. It is greatly appreciated.
who would fit into, we'll call it a near Denny category, don't count on any of that evidence coming in. The law is there, the notice required is there, and it hasn't been given, and if the circumstances don't require it to be given, then you're in the clear. But if it turns out it fits into that category of any evidence, it's not going to come in.
I think we have guidance. Is the jury back? I assume they are.
Well,
I certainly hope so.
Okay, so
I could use a little more guidance though, because perhaps what you're asking of the defense then is for us to bullet point for the court each of the points of our criticism of their investigation and who's involved. Is that what I'm hearing?
No,
No? Okay.
well, you may be hearing that, but that's only your imagination. at work.
Okay.
I did not say that.
Well, I would just like to know what you would like to see.
Yeah, and I actually thought it was clear.
If
Okay,
if
so
I can,
here-
my understanding of the situation,
Here is John Gary. Here is another reason why you cannot talk these things out. I understand that he's thinking aloud and he's, having the reporter do this, but for the love of Cheetos, you have 3 different lawyers who cannot interpret what the hell you're saying or saying. It is mind-boggling. I mean, these are much more smart, well, okay, they're much more learned people than I am. Look, I'm just saying, I have managed to keep all 6 children alive for a number of years, so I'm a little smart, a little tired, but you have 3 different lawyers who are trying to figure out what the heck this guy means, and he can't figure it out. Well, considering I wasn't his target population, I think I would have been okay even without a tattoo. Yeah.
is that you would like the defense to provide, if we're going to have any other named
Thank you, Gigi,
individuals
very much.
who we intend on presenting in the same way that was presented as Sadie Beecham, that those people should be provided to the state by 9 p.m.
Let's do it this way. Let's just pretend that I tell you, you need to comply with Denny, the Denny rule, legitimate tendency, except that the provisions that you bring the motion and have it heard before the trial have been changed to tomorrow. That's what the order is.
So who they are and what the factual circumstances are that meet Denny.
I think
That's
that's,
what
I think that's fair,
Thank you.
right? Well, let's get the jury down. Oh, my goodness.
Even the court reporter's like,
Down,
WTF
please.
is going on? Yeah, I don't like this ruling. Like, just pretend I told you. Look, it's like when I tell my kids, when they were younger to go play hide and seek, and I would be like, "Oh my gosh, you're an awesome hider. I don't know where it is, um, or where you are. You've just done awesome." When I was pretending like I was hiding, I mean, this, for the love of all that is holy, I never, as a pretend judge, would even say, "Let's pretend I said this." That seems like something, I don't know, not pedantic enough for lawyering. It really does. Look, I'm confused most of the time too, to be very honest with you. Well, it would depend on how many bottles of wine. That is a lot of Aquanet in that court reporter's hair. I'm just saying, to get that volume. She has done teased that. Oh my gosh, did we have like escape from jury hell?
All right, folks, I apologize. This happens rarely, but it does happen where the legal issues get very, very involved. And there was an objection made. I'm going to stop it right here. I'm not going to rule on the objection right now because actually I'm going to take some more argument and perhaps evidence tomorrow on some issues. And that will hopefully assist me to resolve the issue that's pending because of the statement in the motion
You
which was
know,
made.
yeah, I'm okay with it. I'll allow it.
We have a very shortened schedule. These are usually things that are done prior to the trial, but
Yeah.
we're going to condense
Here's
them into one.
here's the only thing that I don't particularly identify with as my age. They claim that I am a millennial, and no, no, sir, I am a Gen Xer in my mind. I'm not a millennial, dang it. This is not fair. I am smart. I am beautiful. Oh gosh, who is it? Stuart Smalley. You are smart, you are handsome, and you are worth it. Goodness. Oh, well,
One day tomorrow. And the good news for you is you don't have to be in on it. So I apologize. I know it's disruptive to your schedules. And of course, it means that the case may go longer. But
listen, I was stuck in this cycle where I would have a baby and I would get my body back, and then somehow we're not sure how this happened, but another baby would appear on my doorstep.
um,
I
I
believe
still hope to.
that in this particular stance, it is the Sarah Boone trial where she stuffed her fun-sized boyfriend into a suitcase and beat the ever-living snot out of him by either throwing him down the stairs or beating him with a bat possibly, and or just tossing the daggone suitcase around like those old Samsonite commercials with the, silverback gorilla in them. Or that might have been part of, oh gosh. That might have been a movie, but you get used to chaos. Kids are awesome, but they are also kind of like, "Oh, well, I hope I'm doing this right," and they have nothing to tell Oprah.
Finish within the 2 weeks and 2 days that I had hoped was the outer limit. But this may resolve a lot of issues in the case, what comes out of the hearing tomorrow. So I'm going to ask you to return Thursday at 9 a.m. It is critically important that you not read, watch, or listen to any account of the trial. Discuss it with anyone. It may or may not be available for viewing on the internet or television or anything, but it's not available for you. Believe me, that's totally critical to this matter being resolved fairly before this jury. So do not read or listen to any account of the trial and don't discuss it with anyone. And does anyone have any questions?
Oh, awesome. Yeah, let me see if you
Okay,
guys
so
look, I am not
keep your minds
gonna
open.
learn
Don't
how
make
to
any final
redirect you
conclusions from
tonight. It
what
is
you've
too
heard so
close to
far
9 PM, and I turn into a
from the
pumpkin.
district attorney or Ms.
So
Mueller.
let me
And we'll pick up
gonna
again.
he is just rambling, so we are gonna finish this for now and go to Big Me. So I am not going to learn how to redirect you guys tonight. I will learn that another night. So pop on over to the expert. Um, where David is on, and ask him all about just tell him we need to have a stream about Denny motions and such. Oh, that's right. I can't even promise to somewhat learn to do this until I get monetized. So share with your friend, share the good news of Mo. And, whether you are a motivator or a mofo, all are welcome at the Church of Mo. Yeah, look, John, you may have a completely look, y'all, I know I am going against the grain when it comes to the Delphi case. I understand it. Everyone is like super de duper guilty. And I am like, well, according to whatever they have not proven it yet to me. And I really hope they have more evidence. Um, so, you know, I understand what it's like to be against the grain. John, we try to do things and hopefully we can keep this a place where we all try to learn, and I am coming at this from at least an informational non-bias because Gravely kind of irritates the ever living snot holes from me. Yeah, um I will say, so guys, go to the expert with David and have fun with that. Have a great weekend. I will see you guys tomorrow after I'm working the nursery at church. The fact that my mouth is attached to, a church of any kind is hilarious to me, but, yes, they are letting me be in charge of small children. Because, I kinda have career seniority, if you will. But I will see you guys tomorrow. It will be Church Lady. Now, again, it is a nod to Dana Carvey's Church Lady, but she is Southern Baptist. She is here. She is fabulous. And we are going to be discovering TikTok together, possibly, if I can figure all this out. David got me on the TikToks. I am both ashamed and proud of myself for even getting on there. So I will see you all later. Have a wonderful evening. And we will probably pick up on Monday. We will start day 2 and probably about a 2-hour stream, you guys. I am, doing these kind of life balance things. So I love you guys. I really like you. And I'll see y'all later.